We just got done with oral argument in the case Hawkins v. Youngkin. Our client is George Hawkins. He sued Governor Youngkin over his arbitrary system for voting rights restoration to people with felony convictions here in Virginia. This was the U.S. Court of Appeals for the Fourth Circuit hearing our appeal of the district court's ruling against our case. Our hope is that we win, of course, that at least two of the judges agree with our position here, and that decision could issue at any point in the coming months. And those are the next steps that we're looking forward to. Virginia has a completely arbitrary system of voting rights restoration for people with felony convictions. It violates the First Amendment because voting is a form of expressive conduct. And that is why we brought this case to challenge a system that is unconstitutional. And our client, George, he has served his time. The criminal justice system, that's what the criminal justice system does. People serve their sentences and then they should be fully reintegrated into society. And George deserves his rights back. And at a minimum, he constitutionally, to be consistent with the First Amendment, he deserves to have a fair, non-arbitrary process for restoring voting rights.
This is a point or a case that we shouldn't have to argue, but we here and we argue in this case because it's the right thing to do. And I just kind of feel hopeful. I feel hopeful because even if, this case doesn't go in our favor, I think people like me are necessary. I think people like me are very important in our societies and our communities to continue fighting for what's right and doing the things that we know we need to be doing as a community as a whole, and we're gonna keep fighting.